Be seated, ladies and gentlemen. All right, thank you. We are now ready to proceed with our second case on the docket. Mr. Clerk, would you please call our next case?
Metropolitan Government of Nashville and Davidson County versus Bill Lee et al.
I got to switch sides, didn't they?
Thank you, Your Honor, and may it please the court, Matt Rice, on behalf of the state, I'd like to reserve 6 minutes for rebuttal.
All right.
Metropolitan airports are the gateway to the state. They generate billions of dollars for the state, and they operate using funds from the state. So the General Assembly enacted a law to ensure that the authorities that run these airports consist in part of qualified commissioners appointed by the state. Metro Nashville's challenge to that law fails for numerous reasons. I'll start with why the law is not local in form or effect. And the key to the analysis here is two things. One, how this court interprets the act, and two, what the proper test is for determining whether a law is local or not. And I'll start first with Metro's interpretation, because we think that at least with respect to Section 2.1a, a lot of the harder questions can be avoided through a proper interpretation of the act. So Metro's argument rests on the premise that Section 2.1a's requirement to vacate and reconstitute the airport authority applies only if a county satisfies the population and form of government criteria before June 2025. But nothing in the text of Section 2.1a imposes a June 2025 deadline. In fact, the statute's language directly rebuts Metro's interpretation. The population limit set in Section 2.1a turns on, quote, the 2020 federal census or a subsequent federal census. That language makes no sense if Section 2.1a only applies up to June 2025, because the next census isn't until 2030. So Section 2.1a applies beyond 2025. It imposes an across-the-board rule that if you meet these form of government and population criteria, that you must vacate and reconstitute the board. That is exactly what we had in Burson. You had a population criteria, you had form of government criteria, and this court said that's an open class that is potentially applicable to multiple localities. So we think that under Section 2.1a, if this court interprets that to not include an atextual June 2025 appointment deadline, Section 2.1a falls squarely within this court's precedent. Even if this court accepts the June 2025 deadline and somehow grafts that onto 2.1a, this is probably more relevant for Section 2.1c. I do think that kind of tees up the two very different approaches as to how to determine whether a law is local in form or effect. So the state's test has two parts. The first part of the test is we think the court should look to whether, as it's done in Burson, as it's done in Ferris, it should look to whether the scope of the law, any other locality could fall within the scope of the law without further action by the General Assembly. Once it's made that threshold cut, if there are multiple localities that could potentially fall within the scope of the law, we then think the court needs to look to whether the criteria that are included in the law are rational or not. This rational connection between the substance of the law and the criteria, we think addresses a lot of my friend's arguments with respect to rendering the local legislation clause a mere drafting exercise. Because if there has to be a rational connection between the substantive rule imposed and the criteria that is used, we think that a lot of the kind of hypotheticals, you know, if you target any locality with an NFL stadium, I guess technically other people could fall within the scope of that, but if there's not a rational reason to include that criteria, this court would know that that is targeting a specific locality. We think that's a much preferred test. It'll be more workable, more administrable than what my friends have proposed, which is kind of a probability-based test. In their
But
view,
isn't that sort of trying to link, I guess, the criteria and the reason? I mean, doesn't that open the door to just allowing the state to target? I mean, often isn't the reason why a state might be, trying to regulate a certain locality going to be something that the Home Rule Amendment would have been really designed to prohibit the state from doing. Maybe I'm misunderstanding your argument, but I take you to be saying if there is sort of a good reason for, given the subject matter of the regulation, for the state to establish the criteria that it did for the regulation, then it's okay. Then it's not local inform or effect. But I might be misunderstanding your argument.
I think our position is that if there is a rational connection between the criteria and the substantive rule imposed, that would be not local inform or effect if it's potentially applicable.
But wouldn't that allow, I mean, if the reason why the General Assembly decides to take certain action is because it doesn't like what a particular locality is doing, then there would be certainly a rational link between, the subject matter of the regulation and the General Assembly's choice to limit that regulation to that particular locality.
I should have been more precise, Your Honor. There has to be a rational connection or a rational reason for the criteria other than targeting a particular locality. And we don't think
How is that consistent with the text?
we think it is consistent with the text because it is consistent with looking at to whether this is local in form or effect. And if you use...
Well, you're talking about the reason. How does that change whether it's local in form or effect?
Well,
To say, but they had a good reason for this criteria.
Well, Your Honor, I think I want to start with this court's baseline, which is this court has looked to whether the law sets out criteria that other localities can fall into. And I think what we're proposing is instead of then making a cut based off of probability, how probable or how likely is it that they fall in?
Do we ignore the, if you want to call it probability, do we ignore that if they had a good reason for it? Is that what you're saying?
Yes, Your Honor. In the place of a probability-based analysis, we think that if there is a rational connection between the criteria and the substance of the law that is unrelated to targeting a particular locality.
How does that work with the text of the Constitution?
Well, Your Honor, I'm not making this test up. This seemed to be exactly what this court did in Leach, because there in Leach there was a narrow population bracket of 50 people. That's 12,350 and 12,400. And I guess technically someone could have fallen within that 50, or another locality could have fallen within that 50-person range. But what the court did was it said that this justification, quote, lacked any statement of reasons and was an obvious pretext to target a particular county. This rational connection test that I'm proposing in the place of a probability-based inquiry is the test that has been adopted by numerous other state Supreme Courts, and it avoids this court essentially leaving up the determination of whether a democratically enacted law is going to be voided to judicial intuition. My friends have offered no form of test as to how probable it has to be. 5%?
Are you saying that the Court of Appeals opinion was based on intuition rather than
I think
analysis?
it was based on its intuition that Shelby County would not have formed a metropolitan form of government between 2023 and 2025. And I don't know how you come up with a principal test based off of a probability-based inquiry. Is it 10%? Is it 20%? I don't know that that's going to lead to principled lines. Now, my friends point to Ferris and Ferris's statement that that the rules surrounding the local legislation clause, that it can't just be theoretical that someone will fall within the scope of the criteria. But if you actually look at what Ferris didn't engage in any probability-based assessment. It wasn't the court assessing how likely they thought something was going to happen. What happened in Ferris was they said no locality can fall within the scope of these criteria absent some further action by the General Assembly. So I'm not aware of any cases from this court that engage in any type of probability-based assessment to determine whether a law is local in form or effect or not. Again, we don't think this is a hard problem for us at all in Section 2.1a, because if in 2030, if in 2040, if any locality falls within the scope of the form of government and population criteria, they will have to vacate and reconstitute the board. I think this is the harder question for us is under Section 2.1c, and my friends point out that there are timing deadlines in Section 2.1c. I do want to address, I think it's kind of cross-cutting point from the prior argument. We do think that what they were trying to do in Section 2.1c is provide a transition mechanism for counties that must comply with Section 2.1a's mandate immediately. I do think this case is different from the prior case in that this transition provision does have some kind of substantive difference. It imposes a staggering obligation on the locality, whereas I think in the prior argument there was no substantive different rule, whereas here there is a slight substantive difference in the calling for staggering.
Would you agree, General, that the staggering provision in this legislation could only apply to Davidson County?
Well, Your Honor, we've taken the position that it applied to Davidson County at the moment the law was enacted, that it could have also applied to Shelby County, because Shelby County can at any point in time adopt a metropolitan form of government.
They would have, and okay, I guess that's a possibility, and that's why you say that the state doesn't engage in a probabilistic.
That's why I'm arguing against a probabilistic-based assessment for the Section 21C.
All right, so before we go to the timeline, can we drop back a bit to the Court of Appeals layering analysis? And I'm curious if you think there is a constitutional basis for their layering effect analysis. They begin with counties that have an airport authority, that's 4. Then there's a population-based test, that's 2, Davidson and Shelby. Then they go to a county with a metropolitan form of government, that is only Davidson County. So is there a constitutional basis for our Court of Appeals to have engaged in that layering analysis, or is that poppycock?
I would certainly not call it poppycock, Your Honor. I think that the layering, you have the same layering that was at issue in Burson. There were 3 separate criteria in Burson. So I don't think that the number of criteria, and I don't even take my friends to be arguing that the number of criteria is dispositive. I do think that there is a basis for, if you keep layering on additional criteria, say you got up to 10 criteria or something, at some point I think you're going to have a hard time articulating why there's a rational reason for criteria number 9 and criteria number 10 other than trying to target a particular locality. So I think that's how we would think about it. We don't think it's the number of criteria. We think it's, does it create an open class that any other county can potentially fall into? And if it does, we think that you get around the kind of clever drafting argument by having a vigorous assessment over whether the criteria are rationally connected to the substance of the rule.
Could I ask you to explain, I guess, how this kind of rational reason test that you're proposing, how you're deriving that from the local legislation clause itself? Are you rooting that in just the local form or effect language, or the applicable to a particular county or municipality language?
Yeah, I think we're trying to root that in the local and form or effect, simply because that's where this court seems to have rooted it. This court has focused in assessing whether something is local in form or effect, whether it applies to a class of counties or sets out criteria in which a class of counties could fall into. So I think that's where we're trying to root this rational connection, because I think there's I guess differing approaches for how do you get around the problem of just clever drafting from the General Assembly. I think what we're suggesting is just instead of resorting to a probability-based assessment, that the court should apply what seems to be a more familiar test.
So, but the applicable to a particular county or municipality, that would still mean that if the General Assembly, let's say the General Assembly, enacted a law that applied to 3 counties, but it was the limiting it to only 3 counties was very arbitrary, given the subject matter of the regulation, then you would still have to. That might be a violation of some other provision, exactly, like some sort of equal protection law of the land challenge, but it wouldn't necessarily violate the local legislation clause. Would that be your position on that?
That is our position, Your Honor.
Okay.
We think that the local and form or effect does different work than the applicable to a particular county. Before I would love to move to a particular county if the court wants me to go there, but before I do, I just want to point out that if the court thinks 21A has no June 2025 deadline. So if the court thinks, even if it adopts this probability-based assessment and thinks it's very unlikely that Shelby was going to form a metropolitan form of government before June 2025, it can just sever Section 21C. And in fact, the Regional Airport Authority statute, it doesn't contain any staggering provision. So this court could sever Section 21C, and the municipal or the metropolitan airport authorities would be treated the exact same way as the regional airport authorities. So to the extent the court thinks that it's a problem or it's unlikely, we don't think the solution is to get rid of Section 21A, it's just to sever Section 21C.
So in looking at the reasons for the criteria, what would we do? Would we look at legislative debate? How would we?
I think it would be similar to what this court does when it does when it analyzes whether there's a rational reason for certain restrictions, but instead of analyzing whether there's a rational reason for the law itself, it would analyze whether there's a rational reason for the criteria. That's how the other states have done it. I do want to, we have multiple arguments, so I do want to try to see if I can reach a couple of the other ones. With respect to particular county, my friends on the other side mentioned some statements with respect to the convention debates. And they seem to derive the notion that a particular county refers to more than one county from an isolated statement in the convention debates. But I just want to make sure I point out that this is on page 1121 of the convention debates. The language they point to is a statement from Mr. Pope that it would be a local bill if it applies to, quote, 1 or 2. But then the next 2 lines down, it says, well, suppose it's 3 or 4. And Mr. Pope says, well, they couldn't do it for 3 or 4. And then Mr. Burns says, well, this amendment does say 1, though. And Mr. Pope says, yes. So even the same convention participant who said it could be 1 or 2, he himself later on says, well, the text actually says 1. And I don't think there's any other way to read a particular county than as applying to one county. I don't know why you would include the word particular there, if not to limit it to a single county. So we do think that that is another basis on which this court can rule.
Does the applicable to language require us to look at kind of what the gravamen of the regulation is at all? I mean, the reason I'm asking this, I think that, this act, I think if you ask kind of what is the gravamen of the regulation, right? It's the airport authority. Like it is regulating the composition of the airport authority. But the way in which it does it, also regulates, at least arguably, Metro Nashville, because Metro Nashville did have appointment authority. It's going to have different appointment authority under the new statute. And, that to me is different from the voucher case, right? Where Metro was, we held, that Metro was only sort of indirectly affected by it. It wasn't directly regulated. Here you've got, I think Metro is regulated. It has to do something that it wouldn't otherwise do, but that's not really the focus of the act. The focus of the act is the airport authority, which is a distinct entity. Yes. How do you read applicable to with sort of that question in mind about how we distinguish and where we draw the line?
Yeah, sure. I think there will be difficult line drawing problems. I do think that the applicable to language seems to focus on what is the object of the regulation. In our view, the object of the regulation here is the airport authority. Now, I recognize there could be an instance where, for example, a law applies to an airport authority, but let's say it has something else and it tacks on a duty that is onerous for a metropolitan government. I don't think that would be an out. I just think this case is a little bit easier because we're not talking about a duty here. It's a statutory privilege to appoint. It's not. This doesn't regulate the mayor any more than it regulates the governor or the speakers. They're given.
But the mayor has to do it, right? I mean, the mayor. Let's say the mayor doesn't feel like appointing anybody to the airport authority.
But he should be honored to do so.
Well,
it's your argument, right?
Well, if he doesn't, and in fact he didn't. I don't know that there's anything that requires him to. With respect to the transition here, there were 6 appointees, and the mayor refused to make any appointments. So I think it's an easier case because we're talking about a privilege and not a duty here. If the state gave grant money to Metropolitan Nashville and then it restricted the amount of grant money that it was going to give to them, I don't think that would be a regulation of Metro Nashville.
Well, I mean, but isn't whether something is a privilege or a duty sort of in the eye of the beholder, at least in some situations? I mean, I don't know that that's a really workable line.
Well, Your Honor, I mean, to the extent that this court thinks that any local participation and the privilege to participate in a state-created entity is going to create a local legislation problem if it's modified. I think that creates very perverse incentives because the General Assembly is just not going to include local participation. I mean, if they can't come back and modify or adjust due to a change in circumstances, I think their response is going to be, okay, well, we're just not going to include them and let them participate at all. I do want to try to get to our statewide concern argument, though, because I do think that this is fundamentally a matter of statewide concern that is not local in form or effect. The idea that the local legislation clause allows localities to veto legislation on a matter of statewide concern, it conflicts with the text, it conflicts with the history, it conflicts with the precedent, and it conflicts with the approach taken by a number of sister states. On the text, we think the term local is a problem for a law that has effects outside of a particular locality. I don't think that anyone at the time that this clause was adopted would have understood that a matter of statewide concern to be local in form or effect. This court's precedent supports that approach. I would direct this court, I think City of Knoxville versus Dossett is probably the best case for us on this. And there the court said that the statute in question did not deal with the administration of local affairs, so it did not fall within the restrictions of the Home Rule Amendment. And so, Your Honor, I think that a lot of these harder questions about line drawing can be avoided if this court simply recognizes that. I don't think my friends really debate that the Nashville or the Nashville International Airport is somehow a local affair. They just seem to think that localities have the ability to veto legislation even on matters that are not local affairs. And so I do think that's probably the easiest route here because there's no debate over the nature of the airport. And I think this court, consistent with its prior decision in City of Knoxville versus Dossett, Bozeman, and Cheek versus Rawlings, other states have likewise recognized not only that matters of statewide concern are not local affairs. We've got, I think, 3 different states that have recognized that their airports are not local affairs. That's Texas, I think it's Michigan, and California.
Well, Mr. Rice, do those states have a similar provision to TCA 424102A that specifically says MNAA is an agency and instrumentality of Metro?
Well, I guess a couple points, Your Honor. One, we don't think that statutory label is dispositive for any reason.
So we're to ignore the statute?
Well, no, Your Honor. I mean, I think this court in the Chattanooga-Hamilton Hospital Authority had almost identical language, and it recognized that.
But doesn't it go to your argument of Metro is not the focus of the legislation. The airport authority is the focus of the legislation, but then the statute says that the airport is an instrumentality.
Well, Your Honor, to the extent it's an instrumentality, I mean, the statute does say that. But one, this court has already recognized in Chattanooga-Hamilton Hospital Authority. They had almost identical language, and the court said that's not a county office. And there are no kind of traditional agency-based principles here. The Metro Nashville does not have control over the MNAA, and they have said so repeatedly in litigation to try to avoid liability when they are sued on behalf of actions that are taken.
To Chief Justice Bivens' question, what are we to do with that statute? Are you saying that we ignore it? What do we do? No,
I think, look, this started out when we were talking about matters of statewide concern. If this court wants to engage in an analysis of the fact that it calls it an agency of instrumentality of the locality, I don't think makes it any less of a matter of statewide concern. I think this probably goes more in the anti-Ripper bucket. But I don't think the court should ignore the language. I just don't think the court should let statutory labels dictate.
But the state could have amended that provision too, and they didn't. I mean, the General Assembly could have amended that provision, they didn't do so, correct?
They did not, Your Honor. But I think that Your Honor raises a good point, which is if this is going to lead to local legislation or anti-Ripper problems, and we're going to base everything based off of the label, then we'll just start labeling everything as a state-based agency.
If we were to adopt the statewide concern exception, how are we defining what is a statewide concern for purposes of future cases?
Yes, Your Honor. This court hasn't set out a clear test yet. It has used the phrase local affairs. That's what it referred to in City of Knoxville versus Dossett, if I may finish the question.
You may.
That's what it used in City of Knoxville versus Dossett in Bozeman. It referred to local affairs. And again, I don't think they dispute that this is not a local affair. So I don't know that the court would have to flesh out the contours of the test, but our view is that the focus should be on whether the object of the regulation has a substantial effect outside of the locality. Thank you, Your Honor.
Thank you, Mr. Rice.
Good morning, Your Honors. Melissa Roberge on behalf of Metro Nashville. This court must decide what the Home Rule Amendment protects and what it doesn't. This court has a test to decide that. It doesn't need to come up with a new test. It has a test, and that test was articulated in Ferris, and it has governed ever since. There's no difficult line drawing if the court sticks to the Ferris precedent. The statement in Ferris is that it is the sole constitutional test to see if the statute is applicable statewide, and to do that, you use reasonable, rational considerations. That language does not mean, is the classification itself reasonable or rational? It means you look at who the statute applies to using reasonable and rational considerations. And what you don't do is indulge in the theoretical, the illusory, and the merely possible. We're not asking for a probability test. We're not asking for a new test at all. We're asking for this court to adhere to its precedent in Ferris, its precedent in Leach, and its precedent on Elysian.
Ms. Roberge, can you walk us through a bit the timeline in the statute? As I understand it, the existing airport authority has 7 board members. Am I correct on that?
Correct.
Okay, and then the proposed legislation creates another position. There would be 8 and a different appointments, different sources of appointments. So my question is simply this: can you conceive of a situation where the composition of the board, the number of board members, can exist without some type of timeline or staggering provisions to go from 8 to 7? And what I'm asking is, can you conceive of any situation where this legislation would apply to any county, any airport authority other than Davidson County?
I'm going to answer your last question first. No, I cannot conceive of a situation where it would apply to another county. I believe when you were asking my friend about on the other side about could this apply to Memphis, it couldn't. First, Memphis has tried and failed to consolidate multiple times, and consolidation is a complex process. It requires that both the city of Memphis and Shelby County had passed resolutions to consolidate. And then you have to have an election. And then the election has to be successful. And then you have to have a charter commission. And then they have to propose a charter. And then you have to have another election. If resolutions had been on file in Memphis and Shelby County, the fastest they could have done it, the very fastest they could have done it under the statutory timelines would have been 15 months. But there were no resolutions on file. There was no discussion of consolidation. The legislature designed this act to only apply to Metro Nashville. And I'll go back to your first question about how could they, or what role do staggering provisions play, and are they necessary? 21C does 2 things. It sets the initial term, and then it staggers them. So I can conceive of a statute that doesn't include staggering provisions, but I cannot conceive of a statute that doesn't set the initial terms. That's why 21C can't just be pulled out. If 21C is just pulled out, the initial appointments go on and on and on. They never end.
And Shelby County considered consolidation most recently in 2010, am I correct on that?
2010, and I believe the Sixth Circuit, there was litigation related to that consolidation attempt, and it became moot. And the Sixth Circuit was asked to apply the capable of repetition yet evading review exception. And they said, it's so unlikely that Shelby County is going to try this again in the next half a century that even though we typically apply that exception in election cases, we're not going to do it here. The legislature, if it wanted it to apply to Shelby County, all it had to do was pull out that form of government classification. But by design, this statute only applies to Metro Nashville. But even if this court wants to indulge the theoretical and the possibility that Shelby County could have consolidated on this hyper timeline, it's still unconstitutional under Leach v. Wayne County. Leach v. Wayne County set that in the statute in Leach v. Wayne County, it set a general rule, just like the original Metropolitan Airport Authority Act did, with giving creating municipalities local appointments. And then it pulls out one or two counties. In Leach, they did it with a population bracket. Here, they did it through that multi-level criteria. To find that if it applies to Metro Nashville and Shelby County, that it's somehow a local bill, would require this court to overrule Leach. There's no reason to do that. The delegates did discuss, could it be one, could it be more? Maybe, but the particular county language in the Home Rule Amendment, it works with applicable to. It's not a fourth element. The state is asking you to rewrite Ferris and to rewrite vouchers. 4 years ago, this court set out a 3-element test. Now we're asking for a 4th element. There's no support that each word in that clause is its own separate element. I want to return to this reasonable and rational idea that as long as the criteria is reasonable or rational, it might survive Home Rule Amendment review. Well, we have an amendment that has a rational basis test in it. That's the Equal Protection Clause. Why would we have needed the Home Rule Amendment if it does the same thing as the Tennessee's Equal Protection Clauses? They don't do the same thing. By its text, it applies to any act, local and former effect, applicable to a particular county in its governmental or proprietary capacity. That covers the waterfront of all possible acts. I also want to read to this.
Well, it wouldn't. I mean, isn't it a stretch to say that you wouldn't have needed that because of the Equal Protection Clause under their interpretation? Because, I mean, there's more to the Home Rule Amendment than that. I mean, the Home Rule Amendment specifically talks about local legislative approval, either by way of a vote or by way of 2/3 approval by the legislative body. So that's not really equating what could have happened before to the equal protection. It's not duplicative of the Equal Protection Clause if you adopt the interpretation that the state's arguing, is it?
I want to make sure I understand. I believe that it would be duplicative of the Equal Protection Clauses, because under the Equal Protection Clause, if you have a general law, but you suspend it, that only violates the Tennessee Constitution if there's not a good reason. Well, here, that would be the same thing, and so local approval would only be required when the state had a bad reason for passing the law. That just doesn't logically make sense, that local approval is only required when the state passes a law that doesn't have any rational basis, I don't know how that test could possibly work.
Mr. Roberge, I want to ask you about, I know these, your challenge is based on Section 2, but, there are a number of other sections in this Public Act that apply specifically to an authority in a county having a metropolitan form of government with a population of more than 500,000, according to the 2020 census or a subsequent federal census. So Section 6, for example, Section 7 that, do prescribe, I guess, the authority that such an authority, the power that such an authority would have. Is it your position that those sections, too, are unconstitutional under the local legislation clause? And if not, how is that different? What's different about Section 2?
Section 2 is different because it directly regulates the conduct of the mayor and the council, as Your Honor pointed out during my friend on the other side's argument. Those other sections do directly only regulate the authority, so under this court's decision in vouchers, couldn't be challenged under the local.
So you would agree that the authority is a separate entity that is not actually a county or a municipality for purposes of the local legislation clause, if the regulation is focused on, if the object of the regulation is the authority itself?
That is compelled by this court's decision in vouchers, but because even though the entity is not specifically the county, it is still an agency and instrumentality, and we're talking about the county's appointment power in terms of the Ripper bill, but I would agree for purposes of the local legislation clause that if it only regulates the authority, does not have home rule amendment, does not have local legislation clause protections.
Was the previous act, so the provision that was repealed by this, governing the composition of the airport authority, was that constitutional?
It was, Your Honor.
Why?
Why was it constitutional? Well, it was a general law, so it set the same rule for every metropolitan airport authority. Every metropolitan airport authority, Nashville, Shelby County, Chattanooga, Knoxville, all got to appoint 100% of their boards. That's different under Section 2. So the state has power over these state-enabled entities. What they don't have is the power to pick on one.
How much are you hanging your hat on 2C? I mean, if the General Assembly had enacted this, just Section 2, 1A and B, hadn't said anything about, staggering of terms or how exactly, Metro was to come into, or the airport authority was to come into compliance with this, would that be okay? Or do you think it would still run afoul of the local legislation clause?
Under your hypothetical, Your Honor, is there appointment provisions at all for how the statute?
There are just no appointment provisions. The legislature just said, here's what the composition has to be. It has to be vacated and reconstituted, but we're not going to tell you how to do it.
I do think that is a harder question and would make this case more like Burson, but that's not what the statute does here, and 2.1c cannot be elided. So the court only has to answer that question if you find that 2.1c can be elided.
And why can't 2.1c be elided? And just, if the legislature is able to enact a kind of a substantive provision concerning the composition without specifying anything about compliance or how compliance is to be achieved, then why can't we just elide 2.1c?
So the purpose of elision is used to effectuate the legislature's intent. The legislature's intent here was not to draft a generally applicable bill. It was to draft a bill that targeted Metro Nashville. So if
the purpose of elision is more to bring what was enacted by the legislature into compliance with the Constitution, right?
Consistent with the legislature's intent, Your Honor.
Consistent with the legislature, but not to implement.
Correct,
Okay,
but so
gotcha.
But isn't that the purpose?
That is a better way to say that, Your Honor.
I'm sorry,
Thank you.
isn't that the purpose of a severability clause, though? To allow you to elide one provision of it and still implement the other provisions?
That is the purpose of a severability clause, but that doesn't change the fundamental principle of a lesion, that it's to both bring the statute into compliance, and that compliance must match the legislature's intent. Here, that intent was to draft a locally applicable law. But more than that, there are practical problems with trying to elide 21C. A lesion is a scalpel, it is not a construction project, and it does not authorize rebuilding an entire statute.
That's really the gist of your argument on eliding the statute, right? Because we do it only if we can practically do so, and you're saying it's just not practical here.
It's not, Your Honor.
Okay.
And so just to walk the court through why it's not practical, first, you'd have to pull out 21C. But then we have the problem that I was discussing with Justice Kirby, that the initial appointments go on and on and on. Well, the state has a solution. Let's bring back 105D1 from the dead. But that just causes the court to have to get out its red pen even more. It would have to delete the introductory language to the statute that repealed 105D1 and substituted it not just with 21C, but the entire Section 2. So we've got to rewrite that introductory language to say 105D1 is now substituted for 21C. But the two provisions don't match. 105D1 provided for a 7-member board appointed by one person. So figuring out by the mayor and then confirmed by the local legislative body. Figuring out who appoints when is easy when there's one appointing authority. It's impossible when you have 4 different appointing authorities, because who's stuck with that 8th appointment that isn't provided for anywhere in the law? Well, the statute doesn't tell us that. And the state wants to say, well, you can read 105D1 where it says, and appointments thereafter shall be for 4 years. That is not a provision that was meant to apply to board members 8, board members 9, board members 10. It was meant to apply to terms after the initial term. The legislature made deliberate drafting choices here, and those choices control, and it's up to them, not this court, to fix it.
Ms. Roberge, before your red light comes on, I wanted to ask you about the state's argument that this is really a statewide matter, that there are statewide concerns in operating airport authorities, and people come from all over the state to travel all over the world. And so why is he not right about that?
For a couple of reasons. That is not in the text, that statewide interests are exempt from the local legislation clause. This court's precedent, I'll read from Dossett, when it authorizes exception based on another constitutional provision. It said that it was about the state criminal jurisdiction and the jurisdiction of the courts. It says, but not with respect to the general judicial, let me start over. These are given certain protection from interference by the General Assembly under the Home Rule Amendment with respect to local matters, but not with respect to the general judicial power of the state, nor with respect to jurisdiction over violations of the state's criminal laws. That's a narrow holding that the state's asking you to expand into a statewide interest is whatever we say it is. And while I might agree with you that aviation is a category the state has some interest in, that's not what Section 2 regulates. Section 2 regulates Metro Nashville, not aviation generally. If the state wants to have a voice in aviation, they could have made Section 2 generally applicable to all creating municipalities. But that was not the design of Section 2.
Well, just to follow up on that, how is it local legislation if it's a matter of statewide concern?
If you go back to the text of the Home Rule Amendment, governmental and proprietary capacity. Governmental capacity are those powers from the state, and so that would encompass statewide concern. I'll also draw this court's attention to where the airport belonged before the creation of the airport authorities. They didn't belong to the state, they belonged to the local creating municipality. When Metro Nashville created the authority, and the authorities were created to give local governments flexibility. They weren't created to give the state a voice in aviation. But when they were created, Metro Nashville transferred its property and its power to the airport authority. So it was never a statewide interest of the state.
But as a practical matter, the legislature could have said, oh, they could basically repeal 424102A, dealing with deeming it MNNA an agency and instrumentality of Metro, and they could have deemed it a statewide concern. Could they not? Would that have not avoided the issue?
I don't think that would have avoided the issue, because you would still look at where did these airports belong before? And so our argument doesn't hinge solely on that statutory language. There's multiple factors here that these airports were local. And you also would look to the point of the original act, which was to give local governments flexibility.
But again, they're giving local governments the flexibility, but they also, the power is invested in the state in those instances. It's not invested in the local governments except as delegated by the state, correct?
Correct, Your Honor.
So if that were true, and the fact that the local governments initially have set up these agencies and identified that, then the state, by definition, could still come in and change that later, could it not?
The state could come in and change it generally, but it can't come in and change it for only one locality. I think that's the disconnect. The state does still have power here. If the state wants to enact a general law, everybody will have to fall in line. But if the state wants to enact a local law, the Home Rule Amendment protects the local government. And that's what dictates the result here. Section 2 violates the local legislation clause, and it cannot be elided to save it. I'll turn briefly to our arguments under the anti-ripper provisions. It's a new question, but it can be answered by consulting familiar sources, and we would encourage this court to look at the appointment power, the past practices or history, the statutory designation that we've discussed, the scope of authority, and the funding. Under those factors, the first three all weigh in favor of the Metro Nashville Airport Commissioners being a county office, and the other two are neutral. The appointment power matters. When the court looks to the contemporaneous definition of county officer, appointment power and who selects them is littered all over it. Same with this court's decision in Spurlock. It mattered to this court that the sheriff had been elected by the people of Sumner County. It should matter to this court that the commissioners were appointed by Metro Nashville. Metro Nashville's local sovereignty is protected by the anti-ripper provision, and how it exercises that local sovereignty is by the appointment power. The state...
So Metro's position is that the members of the airport authority are county officials?
Correct, Your Honor.
Okay. And they're not elected, they're not incumbents, isn't that the terminology that's used in the anti-ripper clause?
I think that they would be incumbent, but the anti-ripper provision uses the term selected, not elected. So that covers both elected and appointed officials, like they would be here.
Is there a reason why why are you arguing that this is a county office instead of a municipal office?
Your Honor, to us, that covers the waterfront, that we don't see the constitutional distinction there. like we discussed in the council case, the metropolitan government remains a county.
Well, but our case law also, I think, recognizes a distinction between a metropolitan government and a county government. And so while the county continues to exist as a county, the authority that is vested in the government is vested in the metropolitan government, no longer in the county, right? Whatever authority the county had is really transferred to the metropolitan form of government. So, I mean, it seems to me that there is a distinction, and I'm just curious why, because I think the metropolitan government, as the metropolitan government, is not the equivalent of a county.
Well, Your Honor, that is not an argument that the state has pushed, that the anti-ripper provision would protect us if we had argued that we were a municipality versus a county. The parties have focused on where does this office belong? Does it belong to Metro Nashville, or does it belong to the state? And the state passed enabling legislation and provides a discretionary appropriation, but that's it. Metro Nashville had the local appointment power. The past history that I talked about, where Metro Nashville transferred its property, weighs in favor of finding them connected to Metro Nashville. There's the statutory designation that they are agency and instrumentality, and like I said, the funding is a neutral factor, because the state doesn't fund the airport authority. It doesn't pay the salaries of any of the employees there. It gives it a discretionary appropriation in the same amount that the federal government gives. And so under the state's logic, the airport authority could also be a federal entity. And that can't be the case. We would ask that this court find that Section 2 violates the local legislation clause and the anti-ripper provisions.
So just to go back to my question from a moment ago, so am I understanding correctly then that your argument on the anti-ripper clause relies solely on the county office language? You're not making any argument under the municipal office, or do you just view those as kind of distinctions without a difference? Even though our case law, I think, does recognize a difference between the county and the metropolitan form of government.
It's a distinction without a difference here, Your Honor, because if we're a municipality, it protects us. If we're a county, it protects us. The question before the court is, does this office belong to Metro Nashville?
But your position is you're a county, that Metro Nashville is a county.
That has been our position.
Not a municipality.
Again, I don't think that distinction matters here, but yes, that is how we have framed the issue for the court.
But before we leave the anti-ripper discussion, if we were to hold that this is local legislation, then how is it that the anti-ripper clause even applies?
Well, the first step in the analysis for the anti-ripper provision is the law local and former effect? The state has the power through general law to remove people from their positions. It can't do it through a local law. So that's step one. Step two is, had their terms ended, it was undisputed at summary judgment that the commissioner's terms had not ended. They all had time left to serve. And so then the last inquiry is, do those offices belong to Metro Nashville? And we would submit that they do.
Okay, I guess maybe I didn't state my question very well, but if the act violates the local legislation clause, then there's no need for us to decide the anti-ripper clause, correct?
Correct, Your Honor. I apologize if I misunderstood your question.
Let's say that the act does not violate the local legislation clause. Then how does the anti-ripper clause even apply in that situation? If the act's not local, then how does the clause even apply?
If the court finds that the act isn't local, which would require this court to overrule Leach and to set a new test other than the one in Ferris, but then I would agree with you, the anti-ripper provision would fall as well. But I don't want to presume what this court is going to base its decision on, but there may be situations where the anti-ripper provision would still need to be considered. What hangs in the balance extends beyond Metro Nashville. Any locality could be targeted. The Home Rule Amendment would protect local governments in theory while leaving them vulnerable in practice. That is not the path that the court should choose. We ask that you affirm.
Thank you, Mr. Robert.
Thank you.
So, counsel, I want to follow up on your statewide concern argument.
Yes, Your Honor.
How is the Knoxville airport not a statewide concern? People come from all over to fly in and out of the Knoxville airport.
I think that would
How
likely-
is the Memphis-Shelby County airport not a statewide concern or even a global concern with FedEx and it being a logistics center? But so your point is that the criteria is important to the aim of the act, but a metropolitan form of government seems to narrow it in a way that makes no sense.
I think that would be the appropriate inquiry, Your Honor, and I think my answer to the question is that because of the consolidation of power in a metropolitan form of government, we do think that's a rational criteria. So take the Memphis airport, for example. They have appointments that come from both the mayor of Memphis and the mayor of Shelby County. So you have a diffusion of power. We think it was rational for the General Assembly to be concerned.
There's not state appointment. I mean, this says, your argument is, well, this airport has implications for the entire state, so that's why the airport authority should be appointed by statewide officials, was the legislature's reasoning.
Well, I think the legislature can have multiple reasons, Your Honor. I think I was trying to answer the question of why are we treating metropolitan forms of government different from non-metropolitan forms of government. It's because of the consolidation of appointment power. If you have an ineffective consolidated government making ineffective picks to the board, there's a greater risk than if you have diffused. But I do think, I want to touch on this statewide concern because I think this is of utmost importance because...
Well, before you do that, I have a question about the statewide concern to follow up with what Justice Kirby just asked you. If it's a statewide concern, but there's no new statute that applies to Knoxville or Shelby County or the Chattanooga airport authorities, it only applies to Metro, the Metropolitan Airport Authority, then doesn't that seem like it's targeted at local, that's pretty local, huh?
A couple points, Your Honor. I think I don't have a better answer than I just gave Justice Kirby. The reason it's targeted is because you have a consolidated form of government. I don't think the legislature has to address all matters of statewide concern in one fell swoop. But even if Your Honor did draw the inference that that means this is targeted to a particular locality, I still don't think it's local because it's a matter of statewide concern. We think that the term local in form or effect is limited to local affairs. So you could accept that it's targeting, but nonetheless uphold the law under the language local in form or effect. And you asked where this, I'm using statewide concern as kind of a shorthand.
But doesn't it go to the overall, you're talking about the purpose of the statute, that this is a statewide concern. Doesn't it undercut your argument that the purpose of this statute is to provide for an airport authority that reflects the fact that this is a statewide concern? But other airports have similar effects, and the legislature chose only to address the one in Nashville.
Again, we think they're differently situated because you have a consolidated government making appointments. Even if this honor disagrees with that and you think it means that they're targeting Metro Nashville, we think that they can target Metro Nashville because it's a matter of statewide concern. And so I want to make clear that the statewide concern is not us grafting a new text. It is from the language local in form or effect. The other states that have adopted this doctrine have focused on the word local. There's numerous states that have recognized this doctrine, numerous states, and they have targeted specifically airports. DFW is a great example. And they focus on the word local. We think the history surrounding the local legislation clause supports that interpretation. Hobbs was decided before the local legislation clause was enacted. Hobbs has an extended discussion about the difference between a local law and a general law. And then Bozeman, which was decided right after the local legislation clause, says this is not a matter that is subject to home rule. This is a local affair, and it cites Hobbs. Justice Bivens, I'm sorry, Your Honor.
I have another question, so go ahead. What?
I was going to say, to address your question about the public agency or instrumentality, we don't think that matters. I mean, even accepting it's a public agency or a county agency or instrumentality, which we don't think it is because they don't have control any more than the General Assembly has control over this court. So we don't think it's an agency or instrumentality, but even if it was, we still think that we could regulate that because the state could delegate a matter of statewide concern to a local agency or instrumentality.
Ouch. You're saying that it's a statewide concern so the legislature can focus in on it, but the statute delegates the authority on that to.
And I think what I'm saying is the reason we can modify it, even if we give it to a locality.
But you didn't.
I mean, we did modify the power. We didn't modify the label, Your Honor. I mean, I think even if you accept the label and you accept that this is a county instrumentality, you can still accept that it's a county instrumentality. It's really not because they don't have control and they don't even have the appointments.
Before you get away, I do want to ask you, the test that you're proposing under the local legislation clause, isn't that required? If we were to adopt that, isn't that really, at a minimum, a modification of the test we applied in the ESA case? And perhaps even a total new test for this purpose.
I don't think so, Your Honor. Well, in ESA, this court didn't look to whether it was local in form or effect. It was focused on whether it was applicable to a particular county. But I don't think it's a modification. My friend says that we're asking for a modification of the rule. I think, frankly, the court has a gap. It has said in Ferris that we're going to look to whether it's potentially applicable without action by the General Assembly. But this court has never endorsed any type of probability-based assessment. And to be clear, they have to engage in some probability-based assessment. If I could make one final point, I know I'm over before sitting down, which is just that my friends say that there's no way that you can sever this clause. I would just direct this court to 42-3-104E. That's the regional airport authorities. There is no staggering provision. There can be no, you could sever 21C and say 4-year terms from the time of appointment.
Okay,
Can I
thank
ask
you.
just one quick question?
Okay.
I'm sorry, about, this just goes to your elision severability argument. In the local legislation clause itself, it says that any act of the General Assembly, private or local in form, that doesn't have approval from the locality shall be void and no effect. What do we make of that language? How does it affect whether we can even engage in a severability or elision analysis?
Yes, Your Honor. This case has said in the Lawler versus McCandless that you can engage in elision in the context of a local legislation challenge, but I agree with Your Honor's sentiment that if it truly only applies to a particular locality, there would be no reason to engage in elision. It would just be void, and you could have injunctive relief with respect to Section 21C and none of the other provisions.
Okay. All right. Thank you.
Thank
Mr.
you.
Rice. Counsel, thank you very much for excellent arguments. We appreciate it. And everybody.
Yeah.
Yeah. All right. We will then pick up with our last case on the docket today. Mr. Clerk, if you'll please call our next case.
The Chattanooga-Hamilton County Hospital Authority, doing business as Erlanger Health System versus United Healthcare